Good afternoon again, and welcome to Duke Law School. My name is Tyler Friedman, and I'm a second-year law student here at Duke. I'd just first like to thank Dean Kate Bartlett for her continuing support on these events, and again, Chris Schrader in the program in public law for his generous sponsorship of this event and many others. I'm deeply honored to have played a role in inviting James B. Comey, the Deputy Attorney General of the United States, here to speak with us at Duke today. Jim will speak for about 20 to 30 minutes, and then we'll open up the floor to you all. So I encourage you to think of some questions and take advantage of the opportunity. As you'll soon see, Jim is an entirely dynamic individual, a person who is as intelligent and passionate about public service as he is funny and congenial. As a result of my own longstanding interest in becoming a prosecutor in the Southern District of New York, I sought out a post-college position in that office, and I had the pleasure of working under Jim when he was the U.S. Attorney there. To me, the man that you're about to hear speak should be in the dictionary next to the word leadership. Funny enough, my first introduction to Jim was not during any formal meeting or organized encounter. Instead, it actually happened in the middle of Lafayette Street in downtown Manhattan during lunch hour rush time traffic while I was on my way back from lunch with my new boss. And if any of you know what Lafayette Street is like during the lunchtime hour, it's a pretty messy street. But stopped in the middle of Lafayette Street, instead of brushing me off, fearing for his life and acknowledging the blaring horns, Jim bravely stopped the traffic, stuck his hand out, gave me a big smile, and a very kind welcome aboard. And such run-ins with Jim happened fairly frequently during my year in the office, whether it was chasing him down after a Friday evening cocktail hour with all the new prosecutors, accompanying a trial team to report a verdict, or just being part of an awards ceremony in his conference room after a long gang trial. Jim may have wondered for just a fleeting second who this kid was that always seemed to be around and was always interrupting him on his way to do something. But never once did Jim not stop and speak with me. He always would take the time. He always would share a comment on my enthusiasm to be a prosecutor. And he was also sure to encourage my pursuit to reach such a goal. And what I learned was that's just Jim. He's an incredible leader, and he makes it a point to know and understand the people he is leading. Going into my year at the U.S. Attorney's Office, I thought that I wanted to be a prosecutor in New York. And after my year, watching and learning and absorbing from Jim, I know for certain that I want to be a prosecutor and can only hope to have an ounce of the talent and success that he's had in his decorated career. In 2003, Jim became the Deputy Attorney General, and in his role as the DAG, he's the second highest ranking official in the Justice Department. He helps head a department of more than 110,000 employees with a budget of more than $18 billion and 39 separate component organizations ranging from the FBI, DEA, and Bureau of Prisons to all the various U.S. Attorney's offices and the internal and quite active civil rights and antitrust divisions. Jim also serves as the chair of the President's Corporate Fraud Task Force. But since September 11th, the Justice Department's mission has been quite clear. It's been to prevent terrorism and protect the nation's security. Under Jim's leadership, the Justice Department has developed a foundation of protection, which is nurtured by cooperation and coordination. Jim is no stranger to investigating and prosecuting terrorists himself. In 2001, as a federal prosecutor in the Eastern District of Virginia, he handled the Khobar Towers terrorist bombing case, which arose out of a 1996 bombing of a U.S. military facility in Saudi Arabia, in which a number of U.S. airmen were killed. Our nation's successes in the war on terror are a tribute to the leadership, ingenuity, and tireless efforts of Deputy Comey. Despite the enormity of his responsibilities to our country and the limitless nature of his challenges and his ridiculously hectic schedule, he honors us with his presence here today at Duke. And so on behalf of Duke Law School, it is my great honor to present to you all the Deputy Attorney General of the United States, Jim Comey.
Thank you so much, Tyler. It's really too kind. It's all downhill from here, I'm sure, folks. It's great to be here. The most important part of our session together is actually the second part. I want to share with you some thoughts about fighting terrorism and preserving civil liberties. And then once you've heard what I have to say, I want to hear what you have to say. I want to hear your questions and your challenges and your concerns. So let me start. It has somehow gotten into the drinking water in the United States that the law enforcement response to terrorism has led to a trade-off between civil liberties on the one hand and security on the other hand. It is such a part of the drinking water in our country that there has been such a trade-off by virtue of what we in law enforcement have done domestically, that there's really only two groups left. Those who think that's okay to trade some of their liberty for security, and those who think that's not okay, that there's been too much of a trade-off. I have a modest proposal for you. I want you to open your mind to the possibility that there should be a third group, those who understand that there has not been a trade-off of liberty for security, and as importantly, that there need not be to keep this country safe. Now, it's such a part of our culture that there has been a trade-off that you're sitting there thinking that I am absolutely out of my mind. How could I ask you to open your mind to the possibility that there hasn't been such a trade-off? Well, let me see if I can do a little convincing. It's no easy task for me to get you to open your minds this way because it requires a mastery of detail, a demand for detail, an insistence upon detail to really delve into the debate about whether there has been and needs to be a trade-off between liberty and security in this country. And I'll show you what I mean. Much of the debate in this country since September the 11th, or really what passes for debate about civil liberties, has focused on the Patriot Act. Now, I say passes for debate because I think there's been precious little informed debate about, in particular, that piece of legislation on both sides of the legislation. Instead, what happens is we have people who stand around at gatherings, at a cocktail party, for example, and when someone says, "Isn't the Patriot Act awful or evil?" everybody nods, and then you move on to talking about the NCAA or something else. Or, "Isn't it awful what the Justice Department's doing?" Everybody says, "Yeah, it's awful." And so, "Where'd you get that handbag?" And the discussion moves on. We have town councils all over the country calling for the repeal of the Patriot Act. Now, let me make a statement that sounds obnoxious, but I don't mean it to be obnoxious. None of those folks, not the so-called wine swillers at a cocktail party or the town councils, really understand what's in the Patriot Act. Now, why do I say something that sounds so obnoxious as that? Because they couldn't. They couldn't and call for its repeal. There is so much in it that's so ordinary, so smart, so accepted on a bipartisan basis by people who understand what's in it, that they couldn't call for its repeal. They couldn't if they understand that, for example, in the Patriot Act, the act expresses the sense of Congress that backlash crimes, hate crimes against Arab Americans, against Sikh Americans, are something to be deplored. That the Patriot Act includes additional monies for the survivors of law enforcement people killed responding to acts of terrorism. That the Patriot Act included increased funding for first responders to terrorism. And I could go on and on about things that folks just don't realize are in the Patriot Act. And that if they did, they really wouldn't talk about repeal of the act. In short, I think, though, I said problems on both sides. The discussion of this particular piece of legislation has been bumper stickered. Bumper stickered by opponents, and to be fair, bumper stickered by proponents who have questioned the patriotism of people who question it, who have called people commies, who have problems with pieces of legislation that give power to the government. I don't know about you, but you probably know the answer to this. What drives you crazy about politicians? Among other things, that they speak in generalities. When you watch a television campaign commercial and someone says, "I'm the this candidate," or "I'm the that candidate," or "my opponent is for the rich," or "against the poor," or "for the environment," or "against the environment," I know what you do. You look at the television and you say, "That's great, but what do you mean? What do you mean specifically? What is it about the environmental policy of your opponent that you have a problem with?" I want to know the details, especially because I'm a law student or a lawyer. I know that the details are important. It shouldn't drive you any less crazy in a debate about civil liberties and about the Patriot Act that you don't have the details. You should insist upon them. So let me, at the risk of boring you before lunch in a warm room, let me go into some details that you should demand, and that I hope one of the things I leave with you when I'm done talking is a hunger for the details about this particular topic. In short, I think the concerns about the Patriot Act can be divided into two categories. Stuff that's not new, stuff that's not in it. Let me cover, because I don't have time to cover all the things that are in the Patriot Act, and when you ask me questions, I may be able to respond to some of it. Let me pick some parts that have folks, good folks, particularly concerned. Let me start by talking about libraries. The word library does not appear in the USA Patriot Act, nor does its plural, libraries. There is no mention at all of libraries, and I would bet my life that the people who drafted the Patriot Act never thought about libraries when they enacted Section 215, which gives government investigators working on foreign counterintelligence cases or foreign counterterrorism cases, only those two kinds of cases, no other case, the ability to make a written application to a federal judge to obtain an order to obtain books, records, other tangible items. Now, that books, records business, that's a term of art, that expression for us, and when a prosecutor hears that, he's thinking credit card records, bank records, accounting records. He's not thinking books on a library shelf, but the Patriot Act does give federal investigators the ability, if they're working on those two kinds of cases, to go to a federal judge and get an order for books or records. And theoretically, you could get books from a library, subpoenaed from a library, by virtue of this provision. The Act specifically says that the request cannot be based solely upon First Amendment activities of the person whose records are at issue. Now, let me stop for a second and flash you back to before the Patriot Act. Before the Patriot Act, a federal prosecutor, and I hope a lot of you are studying what federal prosecutors do in criminal law, a federal prosecutor could issue a subpoena for books, records, tangible items, including, theoretically, books at a bookstore or a library, with no showing whatsoever, no involvement of a federal court. A federal agent comes to a federal prosecutor and says, we're conducting an investigation, we need a subpoena for the following records. Zing, it's done. And that's done all the time, hundreds and hundreds of times a week in the United States to investigate crimes, including sometimes, very rare occasions, but sometimes records from a library. I'll give you an example that you should recognize. Ted Kaczynski was the Unabomber, total wacko who had hurt and killed a number of people with his improvised explosive devices that he would send to people. He wrote this equally wacko manifesto that he sent to the New York Times and the Washington Post. Incredibly important clue as to who the Unabomber was. Well, the government developed information that came from his brother, that his brother thought that that was his work. So how did the government go about confirming that? In the manifesto, he refers to a number of very obscure texts, ancient texts and texts that people don't read much. And so government investigators went to the libraries near where Ted Kaczynski had lived over the years and subpoenaed the checkout records to confirm, as they did confirm, that Ted Kaczynski had checked out those books, which was very strong corroboration for his brother's account that I think my brother is the Unabomber. Used in that way in a number of other high-profile cases to find the Zodiac killer in New York, to track down a guy named Brian Patrick Reagan, who was a spy working in the government for the NSA. My point is, though, to tell you that before the Patriot Act, it was much easier for investigators to subpoena books, records, tangible items using grand jury subpoenas, and that is still the case after the Patriot Act. As of September of 2003, the last time we declassified the number, this provision, the so-called libraries provision, which again is not the libraries provision, had never been used. We haven't yet declassified the next number, but let me just tell you, with respect to libraries, quite confident I know what the number is. It's very, very small. I'm not allowed to say, but it's very, very small. It's not a provision that is of great utility to investigators except those who are doing the work that it allows, doing foreign counterintelligence and foreign counterterrorism investigations. A point, though, generally about libraries. I don't think any of us, no matter where you are on the political spectrum, or no matter what you think about civil liberties in America, you don't want libraries to be a sanctuary for criminal behavior. You don't. You don't want it to be a sanctuary for pedophiles, for people who are committing online crimes. You don't want it to be a sanctuary for terrorists. If someone were planning on building a dirty bomb and was checking out a book about how to build a dirty bomb, you would want us to follow up on that. You would want us to follow that lead. I hope that people will think about whether they want libraries to be sanctuaries in the United States. We had a situation last spring that was very concerning to me. We had an al-Qaeda operative come into the United States, and we were very concerned about his presence here, and we tracked him very, very comprehensively and spoke about him every single morning during my morning threat briefing. Where is he and what's he doing? And he was in New York, and he was living in Queens, New York, and he had a computer at his home. But we noticed, the FBI noticed, that he kept leaving his home and going to branches of the New York Public Library and logging on and appearing to use the email. And we worked like crazy to try and figure out what he was doing. And to make a long story short, we ended up confronting him and arresting him. We built a case, and he pled guilty to life exposure. He's facing a life sentence and cooperated with the government. And he's in jail now in Manhattan. His name is Mohammed Junaid Babar. And he admitted that he was an al-Qaeda facilitator, had supplied them with night vision equipment and military supplies, and he had plotted to do a very big explosive attack in Great Britain with al-Qaeda. And we asked him about the libraries. What are you doing? And he said, well, he learned that the New York Public Libraries were scrubbing their hard drives after each user. And so he figured, that'll make it harder for you to track me when I'm emailing al-Qaeda associates from around the world. And when I heard that, my reaction was, what are we doing? You know, we can disagree robustly, but what are we doing when we create a sanctuary for that kind of behavior? Now, because I'm into the details, let me get into another detail here that is a fair concern about the Patriot Act. Section 215, once a federal investigator, an FBI agent investigating counterintelligence, foreign counterintelligence or foreign counterterrorism case, gets this court order to get books and records from a credit card company or a bank, the recipient is prohibited from telling anyone that they got this. This is under a so-called gag order. And people rightly say, well, that's not right. You shouldn't be able to gag people. And again, there are a couple of responses to that I think are very powerful. The first is that reflects a lack of understanding of what we do every day in criminal cases. When we subpoena a bank for someone's records as part of one of the thousands of criminal investigations going on in the United States, by act of Congress, the bank is forbidden to tell the account holder. If it were one of you or anybody, the bank may not tell. There's a statutory gag order. So it's not any different in these kinds of investigations from what we do in other criminal investigations. But there's another string of reasoning that I've asked many librarians to follow through. If you care about privacy, as librarians do, and as I do, and as I hope you do, you would not want the FBI telling a library or a rental car agency or a bank, we're investigating Tyler. We think he might be hooked up with al-Qaeda. We have some information on that, and so we're getting these records to really see what's up with him. You don't want us doing that if you care about privacy. So by definition, the recipient of the subpoena is not going to know the facts, the recipient of the court order. So why then should that person have the ability, the right, the wherewithal to tell Tyler, you're being investigated. The FBI was in here. You're being investigated by them. It has to do something to do with foreign counterterrorism investigations. I would submit to you, if we step back and think about that, the so-called gag order is not only consistent with our practice in criminal cases where we want to investigate in secret for good reasons. We don't want the bad guys to get away. We also don't want to ruin the good guys. We investigate a lot of people on whom we end up not making a case. A lot of people, this won't surprise you, call us and say their neighbor's a terrorist. Or email in or write in and say, well, I don't like that Tyler guy, all comings and goings at all hours of the night, I think he's a terrorist. We have to track that down. But we don't want the world to ruin Tyler if he turns out to be a completely innocent victim of what we call a poison pen. The bottom line here is librarians and libraries do a tremendous amount of good in this world. And what I've said to them, the same thing I'll say to you, I hope that people can dial down the temperature on an issue like this and understand it. Understand what is it the government can get under this provision? How is it different from what you got before? Does it make sense? Why does it make sense? At the end of the day, people may say, yeah, I still think you're full of it on this Section 215 thing. That's fine if they do it understanding the details and knowing why it matters and how it works. I'm not going to go into too many more details about the Patriot Act, but much of it, the criticism of it, is based in part, as with the Patriot Act provision on getting records, on a misunderstanding of how we do criminal investigations. For example, I saw a press release condemning the Patriot Act because it allows the government to secretly access a person's records. As I just demonstrated to you, that's what we do, and do it all the time. In investigating criminal cases, bank fraud cases, mob cases, drug cases, we obtain records and we do it secretly. And maybe as a society we want to say we don't want the government to have that ability anymore. I don't think so. once you understand the reasons that we do that, to protect against the guilty fleeing and the innocent being ruined. But that's a judgment we've made across the board in toll records that we get, your phone records for people who are being investigated, bank records, credit card records, all sorts of records that are used to make the cases against drug dealers, against credit card cheats, against fraudsters. Before the Patriot Act, the rules on obtaining documents were tighter for FBI agents investigating terrorism than they were for FBI agents investigating credit card fraud. I saw a press release that also said, the Patriot Act allows the government to investigate citizens without probable cause and without their consent. Now, when you hear that, that sort of hits you here. But luckily, I'm in a room full of lawyers, or would-be lawyers, future lawyers, who step back from that and say, wait a minute. Probable cause is the standard the government uses to conduct Fourth Amendment activities, search, right, arrest. If we needed probable cause to investigate, or we couldn't investigate in the absence of consent, we'd be in big trouble as a society, because we investigate based on information that a crime might have been committed by a particular person, and we investigate to see if there is probable cause to make an arrest. If you ever set the bar that high, I guarantee you a lot of criminal activity that you want pursued could not be pursued. One other specific, though, that I want to talk about, because there's a lot of confusion about it. You may have heard about sneak and peek search warrants that are authorized by the Patriot Act. We in law enforcement don't use that term, probably because it makes it sound like we're going through your sock drawer while you're taking a nap. But we call those delayed notification search warrants, and they've been around since before anybody in this room was born. And they were created, delayed notification search warrants, by federal judges all across the country who concluded that under the Fourth Amendment it was reasonable, which is the touchstone in the Fourth Amendment, it was reasonable in certain circumstances to delay notice to the subject of a search that there'd been a search. Created sort of patchwork by judges in the Fourth Circuit, in the Seventh Circuit, and the Second Circuit. Each circuit had a delayed notification judge-made rule, and they were all slightly different in terms of what showing the government had to make, what kind of cases were appropriate, how long notice could be delayed. But they were long an essential tool of law enforcement, and that's why judges created this rule. And that's why the Supreme Court in 1979 dismissed as frivolous a claim that delayed notice search warrants violated the Fourth Amendment. And let me give you an example of how this works. I was a federal prosecutor in Richmond, and coming into Richmond was a drug gang from New York where all bad things start. And they were slinging a lot of crack and looking to move into the Richmond drug market. And we didn't know much about them. We had one informant who got in good with these guys, and a very reliable informant with a strong track record. So basically an automatic probable cause informant, demonstrable reliability. And he said, they just delivered 5 kilos of 5 kilos of powder, coke, that they're going to cook into crack, to an apartment on the west end of Richmond that they control. And he was there when they delivered it. But he didn't know much about who was in charge or how big the gang was. We knew it was big and bad. So we had a choice to make. We now had probable cause to search. Do we go in there and grab the 5 kilos and heat all these guys up, expose the informant, and never figure out who the rest of the participants are? Or do we let the drugs walk onto the streets of Richmond? We didn't have to make that choice, because long ago, judges in the Fourth Circuit created delayed notice search warrants. We went to a federal judge and made a sworn application by a DEA agent that laid out all these facts, much better than I've laid them out, and said, if we have to disclose the search, it will do the things we just laid out, endanger the informant and blow the investigation. And so we asked for permission to do the search and make it look like a burglary and delay notice for, I believe it was 60 days. So a federal judge issued a written warrant that permitted that based on that showing. DEA agents went to the apartment, entered, found the 5 kilos, took them, took the stereo, took the TV, and then because all agents are frustrated actors, they took 3 beers from the fridge and poured them down the sink and set them around the kitchen. And then they broke the window, and because we watch TV, they broke it from the outside in. And then they left. And what happened next? The bad guys came home, the 2 leaders, and they called the cops. And they made a burglary report. And we sent a marked unit, a brief police officer, who went there and took a report from these knuckleheads and got all their identifiers. Whose apartment is this? And who you live here? And you are who? And let me see your driver's license. And what was taken? Stereo, the TV, and the blank, I'll bleep out the word, the blank drank our beer. And anything else taken? No, nothing else taken. Okay. So the report's done. 60 days later, let me fast forward. We identify 30 of these characters. We lock them all up, unseal the search warrant, offer to return the TV and the stereo, which nobody wants, and we pay to fix the window. Okay, that's a delayed notice search warrant. The challenge for us, for people like me in government, sorry I'm hitting this, is that just took me 3 minutes to explain. How do we find the 3 minutes in American life to have people listen to what a sneak and peek delayed notice search warrant is? What the Patriot Act did was take that judge-made rule and enshrine it in black letter law in a statute so we have the same standard across the whole country. And I think in an average year we get about 35 to 40 all across the country, total, delayed notice search warrants. We are able to do it when it matters most. And when I tell that story to most people, most people's reaction is, I didn't know that's what that was. I wouldn't want you not to be able to do that. You know, it's under the supervision of a judge, and it requires a written affidavit and a showing of probable cause. Absolutely. But finding the space to have people understand that is our big challenge. And I'm not going to go on and on. The bottom line on the Patriot Act is it, in the main, takes the tools that we used to use for drug dealers, like roving wiretaps. I could talk about that all day. We've done that with drug dealers since 1986, and a bunch of other things like that, and applies them to counterterrorism work and updates a lot of what we do for technology. A lot of our laws that the Patriot Act changed were analog, analog laws that didn't deal with the fact we have voice over internet protocol, that we have all kinds of digital packets being transmitted, and updated that. But the Patriot Act did something that was earth-shattering, groundbreaking, breathtaking, blow you away huge if you're in the business that I'm in. And that was, it destroyed the wall between intelligence investigators pursuing terrorists and criminal investigators pursuing terrorists. And it's beyond the scope of this discussion, but it tends to be beyond the scope of our national discussion because nobody thinks that, well, nobody. Most people don't think that was a bad idea no matter what point on the political spectrum they are. That's not something the ACLU is concerned about. That's not something conservative groups who question the Patriot Act are concerned about. That made us safer. That changed our world. For a variety of reasons, part law, part lore, part folklore, we had created in this country a separation, a wall between those two groups. Best illustrated by my great friend, Pat Fitzgerald, who's now the U.S. Attorney in Chicago, his experience in the 1990s when he was the federal prosecutor chasing Osama bin Laden. He had a squad of agents working with him as he tried to put together a criminal case on bin Laden and the rest of al-Qaeda. And when he did this, he could talk to cops, he could talk to witnesses, he could talk to CIA agents, he could talk to foreign police officers, foreign spies. He even recruited cooperators from al-Qaeda to come in from the dark side, flip 3 guys who are incredibly important and remain important to us. He could do all that with his group of FBI agents conducting their criminal investigation. The one group he could not talk to were the FBI agents across the street conducting a parallel intelligence investigation of the very same people, with FISA, Foreign Intelligence Surveillance Act, surveillance going on of the same people that he was surveilling. They couldn't talk to each other. And as Pat Fitzgerald said, a world in which I could talk to al-Qaeda members, but not to the FBI, was a world in which we were not safe enough. The Patriot Act, by a small change in language, destroyed that wall. So that there still are 2 worlds, intelligence and criminal, but allowed for the growth of a culture that allows them to talk to each other so that we have everybody who's focused on that target able to know what the others are doing. Very, very important. Changed what we do. And people, if you went to Mars in the summer of '01 and came back today, that's what would strike you the most, that culture had been changed, that culture had been destroyed. And Pat Fitzgerald says it best. He said, if you really understand what the Patriot Act accomplished, in particular with respect to this wall, you would believe it wasn't rushed in the fall of '01, but that it came 10 years too late. Let me say, though, before I close and take your questions, a few words about something that's not in the Patriot Act. There's a lot of stuff that's not in the Patriot Act, obviously, but that I hear about all the time and hear about from people who should be asking these questions. but don't realize it's not a Patriot Act issue. Enemy combatants, and in particular a fellow named Jose Padilla. That has nothing to do with the Patriot Act, but it has everything to do with civil liberties and your concern about government power, which I hope you have. The president exercised his authority to detain a fellow named Jose Padilla, who landed at O'Hare Airport, coming in through Zurich from Pakistan, bent on executing a plan to obtain apartment buildings in the United States and simultaneously detonate apartments near the core structures of that, as to demolish the buildings at the same time. And he was trained for this mission, very sophisticated training. And he came into the country, and the government initially grabbed him as a material witness under a provision 18 U.S.C. 3144, which again is beyond the scope of my discussion, but something that I've spent a lot of time on. And he came to me in the Southern District of New York, I think when Tyler was there. And we held him as a material witness, tried to find out what he knew and whether he would cooperate with us. Very, very small window offered by material witness provision, measured in days that you can hold somebody, at most weeks, but then only with their consent. And we found ourselves in a position where we couldn't use the criminal justice system to prosecute him. And I'll talk about that more in a second. So the president made a decision that I was not part of, but I got a call saying, you are directed to turn this prisoner over to the United States military for transport to a military base in South Carolina, where he was designated an enemy combatant. I got this call on a Sunday afternoon, and it shocked me. And it was a breathtaking exercise of presidential power, I thought at the time. And it still is. That an American citizen could be designated after being arrested in the United States as an enemy soldier and incarcerated by the military. Raises very, very important issues. Issues that are now being grappled with by the courts. What's the standard of review that the government must meet? What are issues with respect to access to counsel? There's two other people who have been held in similar circumstances. One, a guy named Hamdi, who's gone back, was captured in Afghanistan, who's gone back to Saudi Arabia. The other, a guy named Ali Al-Mari, who was a Saudi citizen who was arrested in Springfield, Illinois, and is still in custody. But the Padilla case raises the most profound questions, and you, as law students, should focus on this and care about this. And I'm not going to get into litigating the merits of the president's exercise of this power, but I'll say this to you. If you are troubled by that exercise of power, as many, many reasonable people are, you need to answer a question. What would you do? If you were the President of the United States and you found yourself confronted with a situation where you couldn't use the immigration system to incapacitate and deport someone because they're a citizen, and you can't use the criminal justice system either because you have proof beyond a reasonable doubt, but it's proof you cannot use in a court of law because of where you got it from, intelligence sources and methods or foreign government liaison service information. Or maybe the information is information you can use, but it only rises to clear and convincing evidence. It doesn't rise to beyond a reasonable doubt. What do you do? And the answer of a lot of folks, good answer is, I would follow him. When he comes into O'Hare, I would follow him and see if I could make a criminal case. And that's not an unreasonable thing to say. Again, I'm going to sound like a wise guy, but it is the product of too much television, because we cannot follow someone 7 days a week, 24 hours a day successfully. We try it and run the risk in many, many contexts, drug cases, even cases of violence, bank robbery, and run the risk that we will lose the person and that the object of a conspiracy will be achieved. The bank robbery, the drug deal, the fraud deal. But when you're confronted with something where the object of the conspiracy is something that transcends the boundary of the word crime and really dwarfs what we think of as a crime, how do you strike that balance? And how much of that risk are you willing to run that you will lose that person? It's a very, very hard question. The reason I pose it to you is the Padilla case I've discussed in a lot of town forums, and people have gotten all upset about it. I've said, before you get all whipped up, answer that question for me. What would you do if you were duty-bound to protect the people of the United States? And it's a hard one for all of us. And the courts, as I said, Supreme Court is going to ultimately resolve what is the president's authority in this area. But especially if the court concludes that the president has no inherent authority as commander-in-chief or no authority rooted in the congressional authorization to use force from the fall of '01, we all have a question we need to answer. What do we do about the next Padilla? Because they're coming. And Al-Qaeda knows, as well as we in counterterrorism know, the value of a citizen, the ability to freely travel, the ability to come in and out of the United States. They know as well as we do the golden value of the American passport to their efforts. And so if we find ourselves again with the next Padilla, and we can't use the criminal justice system to incapacitate him, and we will use it whenever possible, what do we do? I had a fascinating meeting with the Minister of State from Northern Ireland who said, you know, we in Northern Ireland have spent 30 years working on that question. How do we preventatively incarcerate to avoid horrific acts of violence? What we're trying to figure out now in Northern Ireland is, in an era of relative peace, how do we copy you, the United States, which has the best system in the world for criminal prosecution and criminal investigation? And she said, it strikes me you're coming the other way. You've got the greatest criminal justice system in the world, but you haven't figured out how to deal with this problem, where there's a gap between your criminal incapacitation abilities and your need to protect the American people. I don't have an answer for you, but anyone who's serious about these issues, as I know you all are, as you're here, needs to grapple with this. Because I may be out of government at the point where it's necessary for us to figure out what to do, but all of us have a stake in this, need to participate in this debate. How do we balance our passionate desire for full and fairness against our equally passionate desire to protect the American people? Let me just close by saying that the debate is really good. People should question government power. People should demand to know how the government's using its power. That's healthy. That's the American way. This government was founded by people who had a big problem with government power. That's why we have the Bill of Rights. I mean, that skepticism needs to be part of what you care about. And I need, as a government official, and my colleagues need, to respond to that and explain what we're doing. And there may be some things we can't explain in open forum, then we need to find a classified setting to explain them. Because I shouldn't be doing something that I can't explain to you and that I can't defend. But as we do that, what I hope will happen is that both sides of this discussion, and we're going to have the Patriot Act discussion in the next 3 months. Congress has set hearings where I'm going to testify in April and May. As we have this debate, I hope that defenders of the Patriot Act will dial down their rhetoric and understand that it's patriotic to question government power. And I hope that people who are now very concerned about the Patriot Act will also step back and demand the details. Demand to know. At that next cocktail party, before anybody nods, they say, well, wait a minute, what is it you mean about the Patriot Act? What part? And can you give me the cite on that? Or if you don't want to sound like you're too obnoxious, say, how is that different from what they did before? And in criminal, is that different from a criminal case? All the good questions that you are trained to answer. If you demand those details, and we have an actual discussion in this country, a reasoned discussion, we're not all going to agree. That's also the American way. We wouldn't want everyone to agree on issues of great import. But I hope that you and all of our fellow Americans will at least leave their mind open to the possibility that at the end of the day you will conclude that there has not been a trade-off between liberty and security, and that there need not be. So thank you for helping us all engage in that debate. Thanks. You'll give me the hook on the time. I have to leave, right? Okay, great. Now the fun part. I always want to be a law school professor. Can people pass at Duke Law School? Yes, sir.
Do you think there's going to be any problem with the First Amendment challenge, similar to the Florida Stark line of cases, where we were talking about rape victims and rape shield laws on the non-notification provisions that are in the Patriot Act?
I don't think so, because I think there's a long, and I'm no master of it, but the question was about First Amendment concerns about non-notification. Because of the, I'm no expert in the First Amendment area, but I think there's been lots of litigation over similar, what would you call them? I would, sort of gag order type of things in the criminal context, and in court sealings, for example, and where the governmental interest is so compelling. I don't think that's a problem. I don't think there's a vulnerability there, because again, it's a fairly standard thing in criminal investigations. And so I don't think it's a big departure to do it in counterterrorism and counterintelligence investigations. A lot of people have said to me, well, geez, if you don't use 215, what do you need it for? And why do you get rid of it? And the answer is, we don't need it much. but there may be times when we can't use a grand jury subpoena, either because we can't find a prosecutor or because there really isn't a criminal hook on a particular investigation. We don't know enough yet to be able to say a crime has been committed, but you know, that's something we're going to discuss, I think, in the next few months, and how to change it too. What else? Yes, sir.
Yeah, with the delayed notice warrants or the sneak peeks, you said that, you get about 40 or 50 a year
Yep.
across the United States, and that the standard is probable cause. How many are rejected by judges? How many requests are rejected? And does the public have that information available to them?
Yeah, the Senate and House Judiciary Committees do. We make a report to them. Ooh, I wish I knew the answer to that. I think there were something like in the last year, 47 obtained. And I know I should know this, but the answer is either none were rejected or 3. And I don't know why that's sticky in my head. Yeah, I don't know. That's a great question. I'm going to find out the answer to that. But yes, we make disclosures. The other thing that the Patriot Act is chock full of that we don't discuss much, it's not only judicial oversight, but congressional oversight. We make all kinds of reports on how we're using the provisions, including that provision, how many times we're doing it. But I'll find out the answer to that. It's very, very small, approaching 0. Yeah. What else? Ma'am.
There's been some scholarly discussion about the notion of creating a separate court system for trying terrorists in the U.S. And because of the gap that you spoke of between the criminal law and the national security, do you ever think that's someplace that in such a polarized political environment we'll get to, or do you think it's something that we should strive for, or are there ways that we can work within the criminal justice system?
I think the criminal justice system can do, for example, the Moussaoui case. I'm a big supporter of using the criminal justice system to incapacitate, because we can resolve issues like the conflict between the defendant's discovery rights and the government's need to protect sources and methods, which is at issue in Moussaoui, and we have resolved it in Moussaoui, which is an important precedent going forward. But the challenge is when we can't use it at all in the situation I discussed. The government's position is, at least as to al-Qaeda, the congressional authorization to use force is enough authority for the president. That's a very high-stakes argument, though, because if Congress disagrees, then where are we left? I guess we don't have, as a government, an official position on what the answer should be. You're right, there's been a lot of thoughtful stuff done. Phil Hyman from Harvard did a thick study, which I actually have on my desk. Very thoughtful stuff. Republicans, Democrats, everybody was involved in producing what he did, where he suggests just such a thing. A court system with judicial oversight, with a standard, I think, clear and convincing, with regular review of detention. And we don't have a position on that yet, so I have to be careful saying what our position might be. But we need to discuss that. And I'll tell you, someone made a powerful point to me during another forum like this. They said, you're right, we need to discuss this, and we need to hurry. Because if there's a next attack, the American people are going to be mighty, mighty whipped up, as they must be. And people who care about civil liberties worry, as I do, what the public mood will be then and what it will lead to. And so the people who advocate for having this kind of structure in place say it's got to be in place before the next attack, or people may overreact. So I hope that if you're on Law Review or any other journals, you'll write and think about this, because this is a debate you need to speak into, and don't think you don't have something to contribute. Yes, sir.
I'd like to take a crack at the what would you do question. I don't know the answer to that, and I think if I were President Bush, I would have done exactly the same thing. In fact, I would round up anyone I suspected might even possibly commit such an act of terrorism, because in the end, for me, like, if I were president, a terrible act of terrorism committed on soil while I was on my watch, it's much worse than anything that might happen to one person or 2 people in terms of civil liberties being violated. So I guess my question is it just seems to me that the concern there, and I don't know what the right answer is, it's such a complicated thing, but my concern would be, well, where do you draw the line? And it seems like the legal system is set up to prevent presidents from being able to do whatever it is that they think they should do without certain restraints that we might not like.
Yeah, I think that's right. I mean, that's why we have a tripartite system of government, because you do want to have a break on the executive, because the executive will be focused on protecting the American people. People are dying. I've got to protect them. And you need standards, because when you say, just saying the standard, as you said, exposes how vague it is. People suspected of being involved in terrorism. Like I said, we get all kinds of poison pens. I don't want to pick on Tyler because we haven't actually got one about him yet, but the telling us so-and-so is a terrorist, or information that turns out not to be right. We run it all down in secret, because if that is a terrorist, we don't want him to know we're on him, and if it's not, we don't want him to know we're on him so he can go about his life. But you need standards. I mean, I happen to know the president's view on this. The president's view is, I will do what I think I can lawfully do, but I will respect what the courts do. If the courts disagree with me, that's fine. I believe my job as the executive is to make a judgment about what's an appropriate use of my authority, like the recent judgment he made about that I have the authority to detain a soldier of the enemy, whether it's in Afghanistan or here in Chicago. And if the courts disagree with me, well, that's the American way, and I will abide by that. But as I said, if that day comes, then we all have some thinking to do about what we're going to do next. Yes, sir.
Another question I have is, if we grant the president, the executive, more latitude to do detentions like Padilla and that type of thing, because we're in a war, the war on terror, is there any discussion as to coming up with a legal formulation as to when the war is over? Because, in the past, World War II, whatever, there's an end date.
Yes, terrific question, and one that the courts have struggled with. Judge Mukasey, who wrote the original Padilla District Court decision, talked about this. And ultimately, what the courts have said is, look, we know it's not over now, so we don't need to deal with that. But that's a very challenging question. When is it over? As you said, we're not going to have a signing ceremony on the deck of a battleship with Osama bin Laden, that I surrender, or we've captured the territory, and so it's over. So that's a very, very hard question to answer, and it's one we in the government grapple with all the time. Where are we going to be 10 years from now? And where do we want to be on things like detentions? And it's something that all I can tell you is that we struggle with, and we know the courts are struggling with. I don't have an answer for you.
So it's fair to say that the administration is just hoping that courts come up with a formulation as far as that, and there's no sorts of indicators that they've come up with and where they can say, well, now we can see that this has happened and this has happened, and so this, it's sort of a planning for the future type of thing out of the administration, so that they can look at themselves and say, well, now we think that perhaps we don't have this authority.
I know the administration hasn't come up with a formulation. I know it's one that folks care about, including me, an awful lot, trying to figure that out. I think the administration's legal position might well be, though, that the president, because he is our foreign policy, our warfighting organ of the United States government, that his determination as to whether the conflict is ongoing is, if not the exclusive word, certainly one that's entitled to great deference with the courts. But I don't know that they've formulated, that anybody in the administration has formulated a standard for when we will know. And it's a question I don't think our litigators have been able to answer, except to say, as I said, look, that's a great question, Judge. What we know for sure is that it's not over today. But that's obviously not the full answer. Yeah.
Maybe one more.
Okay. Take one more question? Oh. Yes, sir.
I don't know a lot about the Patriot Act, so thanks for the details. But at the risk of asking a relatively dumb question, all the things that you said, I think I'm relatively comfortable with any expansion of government power if there is good oversight, whether it's congressional, judicial, or both. I'm wondering if there are any areas of the Patriot Act which reduce congressional and judicial oversight.
No. I think that's fair to say. No. Because the Patriot Act provisions, all the new provisions come with three kinds of oversight. Judicial for most of them, congressional for really all of them. We're about to have a terrific period of oversight. I mean, we're going to have, I think, 6 or 8 hearings each in the House and Senate Judiciary Committee. Attorney General's going to testify first. I'm going to be the last batter. I think I got the short straw, but and so there's going to be, I hope, a very robust discussion. And one thing I didn't mention is the Inspector General. We have a very good and aggressive Inspector General who answers to Congress, not to me or the Attorney General, and has been on board since the Clinton administration. And he's charged under Section 1001 of the Patriot Act with receiving all allegations of abuse of the Patriot Act, violations, And I get his report, and Congress does, every 6 months. And what he finds, just what I said to you, is that what people have concerns about, immigration policy, enemy combatants, Guantanamo, which we didn't even get into, have nothing to do with the Patriot Act. And that he hasn't found anything that amounts to an abuse of the Patriot Act. But the challenge for all of us is the Patriot Act has become a vessel into which people pour concerns, legitimate and illegitimate concerns about a whole lot of things. And his job is to sort it out and figure out and report to Congress the Patriot Act, which is, search warrant provisions, certain surveillance provisions, delayed updating of foreign intelligence surveillance technologies, whether there's been any alleged violation of those things. So that's a whole nother level of oversight. But yeah, I think that's an accurate statement. It has not reduced congressional or judicial oversight in any respect. Yeah. So thank you folks for caring about it. Right.